You come home and find a notice on your door. Eviction. Your heart sinks. You don't know what happens next, how long you have, or what your rights are. For millions of Americans, this is a terrifying reality every single year. But here's what most tenants don't know. An eviction notice is not the end. It's actually just the beginning of a legal process that has specific rules, specific timelines, and specific protections built in for you. Understanding exactly how eviction works from the tenant's side could be the difference between losing your home and keeping it. This is the eviction process explained. Welcome to Plain Verdict, where we break down the legal concepts that affect your everyday life in plain language. No law degree required. Today, we're walking through the entire eviction process, step by step from the tenant's perspective. What each stage means, what your rights are at every point, and what you can actually do to protect yourself. Whether you've just received a notice or you're trying to understand the process before it ever happens to you, this video covers everything you need to know. Step 1. The eviction notice. Before a landlord can legally evict you, they must first serve you with a formal written notice. And not all eviction notices are the same. The type of notice you receive determines your options and your timeline. A pay or quit notice means you owe unpaid rent and have a specific number of days, typically 3 to 5 depending on your state, to either pay the full amount owed or vacate the property. A cure or quit notice means you violated a term of your lease, like having an unauthorized pet or unauthorized occupant, and you have a set period to fix the violation or leave. An unconditional quit notice is the most serious. It means your landlord is demanding you leave with no option to fix anything. These are typically reserved for serious or repeated violations, significant property damage, or illegal activity on the premises. The moment you receive any eviction notice, read it carefully, and note the exact type, the deadline, and the specific reason stated. These details matter enormously for your response. Step 2. Your response options. Once you receive an eviction notice, you have several possible responses depending on the type of notice and your specific situation. If you received a pay or quit notice and you can pay the overdue rent, pay it. In most states, paying the full amount owed within the notice period stops the eviction process completely. Keep your payment receipt as proof. If you received a cure or quit notice and the violation is something you can fix it within the deadline and document that you've done so in writing to your landlord. If you believe the eviction is wrongful, your landlord is retaliating against you, discriminating against you, or hasn't maintained habitable conditions, you have the right to contest it in court. We'll cover that shortly. And if you genuinely cannot pay or fix the issue, it may be worth consulting a tenant rights organization immediately about your options before the deadline passes. The one thing you should never do, ignore the notice. Doing nothing is the fastest path to losing your home. Step 3. The court filing. If you don't comply with the eviction notice within the deadline, your landlord's next step is filing an eviction lawsuit in court, often called an unlawful detainer action. This is a critical moment that many tenants misunderstand. The filing of an eviction lawsuit does not mean you are evicted. It means a judge will now decide whether the eviction is legally valid. Once the lawsuit is filed, you will receive a court summons, a formal legal notice telling you the date, time, and location of your hearing. This summons is extremely important. The hearing date is typically scheduled 1 to 4 weeks after filing, depending on your state. From this moment, you have a specific window to prepare your response and gather your evidence. Do not miss this summons. Do not ignore it. Showing up to your eviction hearing is one of the most important things you can do to protect your housing. Step 4. Preparing your defense. Even if you owe rent or have violated a lease term, you may still have legal defenses available to you in court. And if your landlord has done something wrong, the eviction hearing is your opportunity to raise it. Common legal defenses in eviction cases include improper notice. Your landlord didn't follow the correct legal process for serving you. Retaliation. Your landlord is evicting you because you complained about conditions or exercised a legal right. Discrimination. The eviction is based on a protected characteristic covered by the Fair Housing Act. Habitability. Your landlord failed to maintain the property in a livable condition, making rent withholding legally justified. To prepare your defense, gather everything relevant. All rent payment receipts, bank statements showing payments, written communications with your landlord, photos documenting any property conditions, and records of any complaints you made. Organize everything chronologically. If possible, contact a local tenant rights organization or legal aid society before your hearing. Many offer free assistance specifically for eviction cases, and having even brief legal guidance can significantly. Step 5. The court hearing. This is the moment that determines your housing situation. Eviction hearings are typically held in housing court or small claims court, depending on your state, and they move quickly, often lasting only 10 to 20 minutes. Both you and your landlord present your sides to a judge. The landlord must prove the eviction is legally justified. You have the opportunity to present your defense, your evidence, and your documentation. Show up on time, dress respectably, be calm and factual, and bring all your organized documentation. Address the judge as your honor. Stick to the facts. There are three possible outcomes. The judge rules in your favor, the eviction is dismissed, and you keep your home. The judge rules in your landlord's favor. An eviction order is issued, and you'll receive a specific time frame to vacate, or a settlement is reached. Many eviction cases are actually resolved through negotiation on the day of the hearing, often involving a payment plan or agreement to fix a lease violation. Importantly, if your landlord doesn't show up to the hearing, the case is typically dismissed in your favor automatically. If you don't show up, a default judgment is almost always entered against you. This is why attending is non-negotiable. Step 6. After the ruling. If you win your eviction case, the matter is resolved and you remain in your home. Keep documentation of the court's ruling in case your landlord attempts any further action. If the judge rules against you, it's not necessarily over. You typically have a short window, usually a few days to a few weeks depending on your state, before a physical eviction is carried out by a sheriff or marshal. During this window, you have options. You can appeal the court's decision if you believe a legal error was made, though this requires acting quickly and ideally with legal assistance. You can request a stay of execution, which asks the court for additional time to vacate. Courts sometimes grant this in cases of genuine hardship, especially when children or vulnerable individuals are involved. You can negotiate directly with your landlord. Even after a court ruling, many landlords prefer a negotiated departure to the cost and hassle of a forced physical eviction. And critically, even after losing an eviction case, your landlord still cannot physically remove you or your belongings themselves. Only a court-authorized officer like a sheriff or marshal can carry out a physical eviction. A landlord who attempts to physically remove you without a court officer present is committing an illegal self-help eviction, which we covered in our previous video. Before we close, let's recap the most important things to remember about the eviction process. 1. An eviction notice is not an eviction. It's the start of a legal process with rules that protect you. 2. Never ignore a notice or a court summons. Responding and showing up are your most powerful tools. 3. Document everything from the moment you receive a notice. Payments, communications, conditions, all of it. 4. Know your defenses. Retaliation, discrimination, improper notice, and habitability issues can all potentially stop an eviction. 5. Free help exists. Tenant rights organizations and legal aid societies provide free eviction defense assistance in almost every state. 6. Only a court-authorized officer can physically remove you. Your landlord cannot do it themselves, regardless of what any court ruling says. Facing eviction is one of the most stressful experiences a person can go through, but the law gives you more protection than most tenants realize. And knowing your rights at every stage of the process can make an enormous difference to the outcome. If this video helped you, please subscribe to Plain Verdict. We break down a new legal concept every week in plain language, and if you're currently facing eviction or have questions about the process, drop them in the comments below. We read every single one.